Welcome to our presentation on what is probate and when do I need it. Hello, my name is Gary Risley and I am your presenter today. I'm an attorney that's licensed to practice law in Texas, New Mexico, and Colorado. I've been practicing law since 1983. I am the former probate judge of San Juan County, New Mexico. I had the privilege of serving in that position for 8 years when I had to leave the office due to term limits. And a substantial part of my practice is probate law. I've recently been honored in the last 2 years as one of the top 10 providers of estate planning and probate services in the state of New Mexico by a nationally recognized organization, and I appreciate that recognition. I'm the founder of the Risley Law Firm. A large percentage of my practice is involving estate planning, and business law and real estate are also make up a great deal of my practice, and then of course related litigation to those things above occupy a great deal of my time. So what is a probate? Well, probate is the process where we gather up the assets, pay the expenses and bills, and then hand out the property of a person who has passed away. That person we call the deceased or the decedent. And we use the power of the state courts to accomplish this task. Well, the previous slide kind of begs the question. If someone has died, who can gather that person's assets, pay their bills, distribute the estate? Well, the court will appoint someone to represent the person who died. And we call that person, surprise, the personal representative. He or she represents the person who died, has authority over the deceased property pursuant to the court order. That authority gives them authority to gather up the assets, to recover them from other parties, to pay the bills that they were found to be legitimate, to transfer the property as necessary to complete the estate. Now, when we file with the court, what are we looking at? What type of estates do we have? There are basically two different types of estates that are admitted to probate. The first is the testate estate, and the second is the intestate estate. We'll describe those in more detail on the next slide. The testate estate is the one in which the deceased left a will. Remember the term last will and testament? You saw the photograph in the previous slide that had the word last will and testament on it. So a testate estate has a testament, a will, that has to be filed with the court. You invoke the power of the court by making a filing. We'll discuss that in a little bit. The will serves as the cookbook. It's the recipe that guides the personal representative in what to do with the property. The old-fashioned name for a personal representative in a testate estate was executor or executrix. What about the other side? Well, the intestate estate is one in which the deceased did not leave a will. So there is no testament, there is no will to be filed with the court in an intestate estate. So what do we do? How do we know what to do with the property? Well, state law provides that. It serves as the cookbook or the recipe that guides the personal representative as to how to distribute the property. The old-fashioned name for a personal representative in an intestate estate was administrator for a man or administratrix for a female. The power of the court to become involved in the estate of the deceased is invoked through a petition or application. The court doesn't know somebody has died, at least officially it does not do so. Somebody has to invoke the jurisdiction of the court, and we do that through the pleading that we file to get the probate started. There are three basic types of court supervision. The informal probate, we like to do it this way, it's the least expensive, where the court is minimally involved and the personal representative does his or her job without further court approval until the end. There's the supervised administration. Let's call this the moderate or intermediate level of supervision. A lot of times this occurs when we have multiple family members who want to be the personal representative. The deceased died without a will, and they all have equal priority under the law to be appointed, so the court has to decide who gets to serve. And there's other reasons that we also do supervised administration. Sometimes conflicts about assets, conflicts about other things, even conflicts about the will. And then the formal is one where the court enters orders approving basically every step of the way, most of the actions by the personal representative. That's more expensive, more time consuming, so we don't want to go there if we don't have to. In New Mexico, there are two different courts that can handle probates. The first one is the probate court. It is meant to handle informal, non-contested probates. If there's a factual dispute, it has to go to the other court, which is the district court. The district court can handle informal, supervised, or formal probates. Think of the probate court as every man's court. The judge does not have to be a lawyer. It's generally used by non-lawyers to handle small estates if there's not a lawyer involved. A lot of us lawyers do like to use the probate court. It's less expensive to file there, and you can get things done relatively quickly and not tie up the district court judges who tend to be very, very busy in the state of New Mexico. But there's times you need a district court. You have a lawyer judge. Now you can file pro se, that is by yourself, for representing yourself, but the rules still apply. And all contested matters must be filed there. It is the only court of record. The probate court doesn't have a court reporter. It doesn't have those type of things where a factual dispute can be determined. The judge in probate court can rule on legal issues, but not on contested issues. As stated before, the job of the personal representative is to gather the assets of the deceased, pay the bills and expenses owed by the deceased, hand out the remaining assets according to the will or the laws of intestate succession. And again, under intestate succession, the heirs of the deceased are those that are designated by state statute. It may all go to the spouse, or it may go to the spouse and the decedent's children if he had a previous marriage, for example. It depends on the nature of the properties. In community properties, it's separate property. It gets really detailed really quick, but there's a process to determine who the property should go to. And again, I can get a lot more detail, but that's not the purpose of this presentation. Just recognize it's a rare occasion that a property would be, what we call escheat, be transferred to the state because we could not find an heir of somebody who has died. So when do I need a probate? Well, if the deceased owned any real estate that's not transferred by a recognized non-probate transfer method, and we're going to talk about that in a little bit, you need to do a probate. If they did not own land, but their estate's worth over $50,000, guess what? You need to do a probate. If there's any dispute between the decedents as to who are the lawful heirs here, and it happens all the time, folks. There's a dispute about the validity of any of the will. Another one, if there's a minor children, we need a guardian. There's those type of things that we need a probate. So let's talk about real estate a little bit. So it's important that you understand that real estate is governed by the law of the state where the property is located. So John Jones or Jane Smith may have died in Massachusetts, but they owned real estate, a cabin, oil and gas interests, whatever the case may be, in New Mexico. The laws of New Mexico apply as to the real estate. And guess what? We usually end up having multi-state probates. So there's a Massachusetts probate to handle the things, everything. There'll have to be a probate here in New Mexico or Colorado, whatever the case may be, to handle those type of probates for that particular land. So we do handle those. Again, that's for another presentation. We can handle out-of-state probates that are not contested in any county in New Mexico or Colorado. Mineral interest, oil and gas royalties are a great example, are real estate and must be transferred by deed. So if you're getting oil royalty payments on a property and your family used to own the land 100 years ago, even though they sold off the surface 50 years ago and kept the mineral interest, that is a real estate interest that must be transferred by deed. There are various ways to do what we call non-probate transfers. I'm only going to talk about two of them. The transfer on death deed, the TOD as we use the abbreviated to be, is a deed that states where a landowner says, when I die, I hereby transfer my property to my son and daughter, charity, whatever the case may be. My spouse. It does not come into effect until the person dies. It can be revoked at any time until that time, as long as the creator is competent. If the creator of the TOD transfers the property to somebody else on a sale, it voids the TOD. It doesn't affect your ability to get a mortgage or anything. So basically if I haven't done anything else with this property at the point that I pass away, you get it under the TOD, the transfer on death deed. The joint tenancy deed is one of two types of tenancy that are generally recognized, the other being the tenants in common. Under a joint tenancy deed, last man standing wins. So we have A, B, C is listed as joint tenants on a deed. A dies. B and C are the new owners of the property no matter what the will of A says. It automatically went to them as an operation of law. Now B dies. Sounds like an Agatha Christie mystery, doesn't it? C gets it all. C's the last man standing. Now compare that to a tenant in common deed. A dies under a tenant in common deed. A's heirs or devisees under his will get his interest in the property. The same thing when B passes away. They own every molecule, 1/3 of every molecule. Among it is tenants in common. But when you die, your interest goes to your estate, not to your co-owners. That's the difference. So joint tenancy deeds are a tool that we use to transfer property outside of will of probate. All right, small estates. Those under $50,000 in total value and which hold no real estate, for which there's no will, may often be handled by a small estate affidavit. There is also a state exception dealing with homesteads. We're not going to discuss that in this presentation. Estates over $50,000, or a lot of times the bank, the stockbroker, or other financial institution is not willing to cooperate and just take your affidavit. If any of those things occur, we need to go file a probate to get things handled. In the majority of cases, if you need a probate, I would encourage you to hire a lawyer who practices regularly in this area. Not some guy. Everybody says they can handle a probate. Everybody thinks they can do a will, but can they do it well? And it's the gotchas that create the problem. So I'd encourage you to hire a lawyer. We make a lot more money on cases where somebody undertook the probate by themselves without a lawyer and messed the whole thing up. Now I got to unwind the whole deal, kind of like trying to unscramble a bowl of spaghetti after it's been mixed in the bowl. So let us help you earlier. It's money well spent. Probates are what we do. Again, we can handle uncontested probates anywhere in New Mexico or Colorado. We know what paperwork needs to be filed. We know where the notices need to be done. We draft the documents that you need to handle. We let our personal representatives handle the day-to-day work, gathering the assets, paying bills, etc. But we provide the paperwork, make sure they stay on task, and make sure everything's filed appropriately with the court. It is fairly complicated. We do them all the time. You may do one or two in your life. So that's the difference. So we can handle contested probates anywhere north of Albuquerque and west of I-25 in New Mexico, and we can also help you out with contested matters in Southwest Colorado. I can handle matters in other parts of the state. I am a pilot. I have a plane. I can get to hearings in just about anywhere in Colorado or New Mexico fairly rapidly, but it becomes a cost factor. It probably would need to be a pretty large estate before you hired me to go traveling all over the state of New Mexico or Colorado. But there are times I have done that, and I'm in a case or two now where I am doing that. But we're here to help you through the process. I hope this presentation has given you a basic understanding of what you need to do. You can give us a call at 505-326-1776 to schedule an appointment. We will sit down with you, review your documentation, and advise you what actions we need to take on behalf of you or the person who's passed away. Our job is to be objective with you, lay it out for you. We can quote generally an uncontested probate. We can quote you a fee. So we look forward to working with you, and thank you for taking the time to listen to this presentation. See you soon.